5 years after their divorce, Sarah Smith and Brian Berg are still fighting over the same house, and now she's had to evict his tenants just to get it sold. This 2026 Michigan family court hearing reveals what happens when ex-spouses become reluctant business partners. The judge has already ordered the sale once. Today, he's deciding whether to force it through.
I could give you the number for witnesses. They told me I could. And one is a witness to all the garbage in the garage. And they both can state about how much the house is actually worth. And
Okay.
I had to serve eviction notices to the people he has living there. And he was trying to keep it secret from me. And the person that he has living there also got evicted from her other place because of garbage and police coming there. And she got her kids taken away because the house was dirty. And she's living in my house that I'm trying to sell.
Okay. All right, Mr. Berg,
And-
what do you say about that? Oh, I'm sorry. Go ahead. Are you I thought you were finished, Ms. Smith.
Oh, and then as far as the property taxes go, I had to contact them so I can get copies of the bills. And I have my receipt of that I've paid more than half. I paid, well, I have the receipts. I paid a total of $814 and he's only paid $2. That's what he said.
Okay.
Disagree.
Yeah, Mr. Berg, I'm gonna give you a chance here in just a second. I just want to make sure Ms. Smith tells me everything that she wants to tell me first.
Yeah, I'm
So
just
can you state that last part again, Ms. Smith?
about the property taxes.
Yeah.
It went into arrears because I paid one and he was gonna pay the next one that was due and he didn't. And it went into arrears. I had to go up there and I paid 651 of that. And he told me he paid 200. And that's what the clerk said to me. And then I have another receipt for 162.54 that I paid in January of 25. Because that was my half from another one. So that's what I paid it. And he won't fix anything on the house to make it look better. And I have a receipt of my half of the privacy fence that we agreed to pay. And he didn't get his half. And I have the receipt for my half that's already up. Yep, and I have the number of the realtors that I can give you also if you want to speak to them. Did you want those phone numbers?
Well, I can't just call up people and ask them questions. What we would have to do
Well,
is have a hearing.
Because I already talked to them today and they said they'd be more than willing to, talk to you. So that's part of my proof.
Sure, and I understand that, but I have a procedure that I have to follow in court.
Okay.
I can't just have informal conversations with people on the phone as a judge.
Okay.
Those people would have to come in and they would have to be sworn in, and Mr. Berg would have to have an opportunity to question them as well. So that's how things work in court. We can't just have informal conversations. They have to have evidence and they have to be under oath and testify, and both sides have to be able to ask them questions. So
Okay.
That's certainly something we can do, and they may be able to offer helpful testimony, but I have to follow the correct procedure. Do you understand that?
Yes. And
Okay.
Brian also, he wanted to leave it up to me to find the realtors to put a sign to sell the house. And he's complaining that I don't find the realtor, but it's both of us that have to sell the house, not just me. And I'm the one doing all the work.
Okay.
And the one realtor brought a guy out there and he didn't even want to go in and look at inside the house, which is like nicer. All he saw was the outside and all that garbage, and he wouldn't even go in. And I got a cash offer, and Brian didn't want to agree on that. And it's been almost 5 years that the house it hasn't had a.
The judge is explaining a fundamental courtroom rule. Hearsay doesn't count. Miss Smith spoke to realtors outside court, but those conversations can't become evidence without formal testimony. This protects both parties. Mr. Berg gets to cross-examine, and the judge evaluates credibility in person. Under Michigan court rules, sworn testimony with cross-examination remains the gold standard for contested facts.
Sign in
Okay.
front of it for a couple of months.
Several months.
All right, let me hear from Mr. Berg now. Mr. Berg, what's your side of this?
I have paid on the taxes, when I was working for Grand Traverse Plastics. And, I do have the receipts, and I'd also like to request a formal hearing in person, to prove the documents.
Well, that's one part of it. We could certainly do that. And I think, I think we're gonna need to have a hearing here in person where Ms. Smith has some of these agents come in and testify, or at least one of them. But Mr. Berg, I mean, what's your side of not cooperating with selling this house?
As far as selling a house, I'm still willing, but I'm feeling that I'm getting lowballed on these offers. I do have the state assessed value of it, and it's assessed at just the taxes is like $56,000.
So what have the offers been?
I'm not for sure because I was never contacted by the realtor. I was contacted, but they never made the offer. They never explained the offer to me.
Well, then how do you know you're getting lowballed on offers if you don't even know what the offer is?
Well, what I'm saying is they suggested 70,000, and I know the
Okay.
house is worth at least 100.
So what you're saying is that the asking price that the realtors are suggesting you think is too low?
That is correct.
All right, well, I think what we need to do is have a hearing. So Ms. Smith, if you have one or more of those realtors who is willing to come in and testify, then you're gonna need to contact them. The court will give you and Mr. Berg notice of the date of that hearing.
Okay.
And you're gonna have to contact them and let them know and have them come in to testify. Otherwise, I'll just go on the testimony of what you both have. Also, both of you, to the extent that we have issues regarding the payment of property taxes and other issues, both of you will need to bring in whatever documentation you have of amounts that you've paid and so forth. And so, I'm looking at the agreement that you guys made back in July of 2023. And it does indicate that you are to agree on a realtor who will sell the home. And after paying the cost, Mr. Berg will get 40%. In the meantime, you'll evenly split the cost of insurance and evenly split the cost of real estate taxes. So to the extent that Mr. Berg, that you haven't paid your share, you're going to be required to do that, but you'll have an opportunity to bring in proof if you believe that you have paid your share. And I'll have to make a decision.
I do have.
Just a second.
Mr. Berg's objection reveals a common post-divorce trap: emotional attachment to property value. He knows the house is worth $100,000 despite never seeing actual offers. Family courts regularly see this. One party's stubbornness can stall sales for years, eroding value through taxes, maintenance, and market shifts. The judge's solution: force the evidence into the open through sworn testimony.
Ms. Smith is
Oh, I thought my screen went blank. I'm sorry.
yeah. No, it's hard because I can't see you either. So, Mr. Berg, you cut out there.
I do have the receipts for the taxes that I have paid. And also the people that were living here are no longer here.
Yes, if I may, I do
Yeah.
have eviction notices for the ones that were staying there. They're supposed to be out by April 11th. And if they're not, I got the eviction notices to file. Because they're not paying rent or anything.
Yeah, that's a whole separate issue from the sale of the house, but so I'll set this for the hearing. The court will hear what whoever shows up as a witness has to say, including testimony from both of you. And then I'm going to order that the house be sold. And Mr. Berg, I mean, to the extent that you're not cooperating, you know, this, I tend to agree with Ms. Smith. This has been going on for a long time. We were back here in April or last October. You said that you would cooperate. This house needs to get sold, and it is going to get sold. The only thing that we're going to be doing at that hearing is whether or not the real estate agents have an appropriate selling price and listing price and so forth. So
when the realtor, the last realtor that come out here, she said she would get back with us, and she never did.
She brought a guy out
Oh.
here to look at the place.
That was a gentleman that was looking at the house to purchase it.
He didn't even want to come in. But
all
I'm,
right, this isn't really a time for the two of you to
No,
argue
I know.
back and forth. You can
he
do
doesn't
that
believe
outside of. You can do that outside of court. I'm gonna set this for a hearing. You can both testify, and I'll determine who is more believable. You're both telling very different stories, so I'll have to make a determination based on your testimony and the testimony of any realtors. And again, Ms. Smith, I would highly recommend that those individuals that you've indicated are willing to testify, that you make efforts to have them come in. Otherwise,
oh, I can't hear you.
I'm going to have to just go on what you have to Berg has to say. So, all right, the court is going to set this for a hearing. The court will send out notice of the date and time of that hearing to both sides. Again, you need to bring whatever witnesses and whatever evidence you both have to that hearing date. That'll be the only date for the hearing. So if you don't bring evidence, then we'll proceed without it. I won't adjourn it or set another date after that, because this needs to get taken care of and over and done with. So again, we'll provide notice of the date and time of that to both of you. Ms. Smith, do you have any questions?
No.
Mr. Berg, do you have any? Go ahead.
My eviction, never mind. That's fine. Okay, I'm good. Sorry. I'm fine.
That's all right. Mr. Berg, do you have any questions at all?
No, sir, I do not.
All right, thank you. That's all for this hearing today. Again, look for that notice, and both sides are free to disconnect at this time.
Okay, thank you. I don't know how to disconnect.
Okay, Mr. Sassung, you're appearing on behalf of Kalkaska Memorial Health Center, is that correct?
I am, Your Honor. Yes. Good afternoon.
Okay, 1 second here. Okay, we'll go on the record in Kalkaska Memorial Health Center versus Faribault, file number 2615028. The record should reflect that counsel for plaintiff is present by Zoom. And sir, you're Jeffrey Faribault, is that correct?
Yes, sir.
Okay, Mr. Faribault appearing today. And Mr. Faribault, do you have an attorney in this case?
I do not, Your Honor.
Okay. All right, so we're on the record in this case. This is the first hearing. This is a scheduling hearing to set some dates for going forward. Mr. Sassung, just want to get a sense from you. Have you had any discussions with Mr. Faribault? Is this something that we can, have mediation or something like that to attempt to get it resolved early on? Do you want to set a lot of dates in this? How did you want to go forward with scheduling?
Thank you very much, Your Honor. I have not, in answer to Your Honor's question, had an opportunity to speak with Mr. Faribault, and I certainly am willing.
The judge scheduled a contested evidentiary hearing with formal witness testimony from realtors and both parties. He warned this would be the only hearing, no continuances. The court will determine the appropriate listing price and order the house sold, with Mr. Berg potentially liable for unpaid taxes. Both parties must bring all documentation of payments made. A divorce decree is only the beginning. Enforcing property division often requires returning to court. When ex-spouses become business partners in real estate, judges can and will force sales to end the deadlock. The lesson: structure divorce settlements with clear enforcement mechanisms or prepare for years of litigation. Subscribe for more real courtroom battles and the legal lessons hidden inside them.